June of 2014, the United States Supreme Court issued its decisions in two long-awaited cases dealing with the search of cell phones incident to arrest. California versus Riley dealt with a smartphone, a phone that was in the pants pocket of Mr. Riley when he was arrested on a traffic offense. The officer making the arrest noted that on the cell phone were various indications or words associated with gangs. 2 hours later, at the station, a gang expert further investigated the cell phone and discovered pictures and videos which linked Mr. Riley to a recent shooting. As a result of the digital information found on his phone, he was charged and convicted, and his sentence was enhanced due to the gang affiliation. His case was sustained up through the appellate process. United States versus Wurie, on the other hand, dealt with an old-fashioned, if you will, flip phone. Mr. Wurie was involved, the officers believed, in a drug deal. Upon the search incident to arrest, the officer noted that the phone had several calls coming in from, quote, my house. And looking at the phone log and tracing the number, they were able to determine that it was Mr. Wurie's house, and a warrant was executed where additional evidence was obtained. He was convicted, it was reversed on appeal, and the state took it up to the United States Supreme Court ultimately. Now, these two cases are important because, as we'll see in a few moments, the United States Supreme Court addressed the concerns and the magnitude of the rights of citizens and the challenges facing law enforcement in what we call the digital age. In dealing with Riley and Wurie, the United States Supreme Court, first of all, discussed the possible precedents that they could apply. The three related precedents that govern the extent to which officers may search property found on or near an arrestee without a warrant include Chimmel versus California. In Chimmel versus California, as you recall, this was the search incident to arrest in an individual's home and a search of the lungible area. The court in that decision said that the officers had to be concerned about harm to themselves with the arrestee lunging for a weapon or lunging and destroying evidence. The digital data stored on cell phones does not present either Chimmel risk, the court noted. Digital data stored on a cell phone cannot itself be used as a weapon to harm an arresting officer or to effectuate the arrestee's escape. Officers may examine the phone's physical aspects to ensure that it will not be used as a weapon, but the data stored on the phone can endanger no one. To the extent that a search of cell phone data might warn officers of an impending danger, that the arrestee's Confederates are headed to the scene, such a concern is better addressed through consideration of case-specific exceptions to the warrant requirement, such as exigent circumstances. Now, again, we will discuss that in a little bit more detail in just a few moments. But again, the court is saying exigent circumstances can still apply to the search of a cell phone, but those facts are going to be greatly limited. Secondly, the court noted the United States versus Robinson analysis, whereby a cigarette pack found in the arrestee's person was searched. And in that case, in applying Chimmel, the court held that the risks identified in Chimmel are present in all custodial arrests. That is to say, the destruction of evidence or the possibility of there being a weapon. Consequently, the court allowed the evidence that was seized from the cigarette pack in the Robinson case. In these cases before the court, Riley and Wurie, the court declines to extend Robinson's categorical rule to searches of data stored on cell phones. The third precedent the court noted was Arizona versus Gant, which permits the search of a car where the arrestee is unsecured and within the reaching distance of the passenger compartment, or where it is reasonable to believe that evidence of the crime of an arrest might be found in the vehicle. The court refused to extend that precedent or that logic because, as the court noted, it would be a particularly inexperienced or unimaginative law enforcement officer who could not come up with several reasons to suppose evidence of just about any crime could be found on a cell phone. Accordingly, that proposal is not appropriate in this context and would prove no practical limit at all when it comes to cell phone searches. Now, the United States Supreme Court, as I said, they got it in this case. They elaborate the reasons why the precedents would not be applicable. The court noted that these cases, Riley and Wurie, require us to decide how the search incident to arrest doctrine applies to modern cell phones, which are now such a pervasive and insistent part of daily life that the proverbial visitor from Mars might conclude they were an important feature of human anatomy. A smartphone of the sort taken from Riley was unheard of 10 years ago. A significant majority of American adults now own such phones. Even less sophisticated phones like Wurie's, which have already faded in popularity since he was arrested in 2007, have been around for less than 15 years. Both phones are based on technology nearly inconceivable just a few decades ago when Chimmel and Robinson were decided. Absent more precise guidance from the founding era, we generally determine whether to exempt a given type of search from the warrant requirement by assessing, on the one hand, the degree to which it intrudes upon the individual's privacy, on the other, the degree to which it is needed for the promotion of legitimate governmental interest. In other words, the balancing test. The rights of the individual citizen versus the governmental need for law enforcement. Modern cell phones as a category implicate privacy concerns far beyond those implicated by the search of a cigarette pack, as in Robinson, a wallet, or a purse. Cell phones differ in both quantitative and qualitative sense from other objects that might be kept on an arrestee's person. In other words, the Supreme Court is about to go into detail to distinguish physical items that may be found in a person's wallet, in their pocket, from the vast types, scope, quality, and quantity of digital information. One of the most notable distinguishing features of modern cell phones is their immense storage capacity. And this capacity has several interrelated consequences for privacy. Now, again, as we know, at the root of the Fourth Amendment is this expectation of privacy. The privacy of where we go, the privacy of what we read, the privacy of what we have, the privacy of our life, the privacy of our medical records. The Supreme Court then addresses a lot of these concerns. First, a cell phone collects in one place many distinct types of information: an address, a note, a prescription, a bank statement, a video, that reveal much more in combination than any isolated record. Secondly, the court notes, a cell phone's capacity to allow even just one type of information to convey far more than previously possible. The sum of an individual's private life can be reconstructed through 1,000 photographs labeled with dates, locations, and descriptions. The same cannot be said of a photograph or two of loved ones tucked in a wallet. And thirdly, the data on a phone can date back to the purchase of the phone or even earlier. A person might carry in his pocket a slip of paper reminding him to call Mr. Jones. He would not carry a record of all his communications with Mr. Jones for the past several months, as would routinely be kept on a cell phone. Finally, there's an element of pervasiveness that characterizes cell phones, but not physical records. Prior to the digital age, people did not typically carry a cache of sensitive personal information with them as they went about their day. Now it is the person who is not carrying a cell phone with all that it contains who is the exception. According to one poll, nearly 3/4 of smartphone users report being within 5 feet of their phones most of the time, with 12% admitting that they even use their phones in the shower. The court went on to note that although data stored on the cell phone is distinguished from physical records by quantity alone, certain types of data are also qualitatively different, such as an individual's private interests or concerns, historic location information. Mobile application software on a cell phone or apps offer a range of tools for managing detailed information about all aspects of a person's life. In fact, in 1926, Learned Hand observed that it is a totally different thing to search a man's pockets and use against him what they contain, from ransacking his house for everything which may incriminate him. In other words, the court is saying that the information contained, especially on a smartphone, is vast. It would be like ransacking somebody's home, and even more so because it would also impact the rights of third parties, such as providers of cloud storage. Again, the United States Supreme Court is aware of the balance. Indeed, the court noted, it's true that this decision will have some impact on the ability of law enforcement to combat crime. But the court's holding is not that the information on a cell phone is immune from search. It is that a warrant is generally required before the search. I want to spend just a little bit of time of going over some of the arguments that were made by the government as to why a warrant should not be required. They're the arguments that many of you have discussed with each other and with those of us at the Academy as to concerns about what might happen with respect to a cell phone and its use at the time of arrest. For instance, remote wiping. The government's primary concern turns on the actions of third parties who are not present at the scene of the arrest. And data encryption is even further afield. There, the government focuses on the ordinary operation of a phone's security features, apart from any active attempt by a defendant or his associates to conceal or destroy evidence. And the court noted that they had really very little reason to believe that these problems were in fact prevalent. The briefing reveals only a couple of anecdotal examples of remote wiping triggered by an arrest. Similarly, the opportunities for officers to search a password-protected phone before data becomes encrypted are quite limited. Officers are very unlikely to come upon such a phone in an unlocked state because most phones lock at the touch of a button or as a default after some very short period of time. The court went on to state, in any event, as to remote wiping, law enforcement is not without their own specific means to address the threat. Remote wiping can be fully prevented by disconnecting a phone from the network. And there are two ways to do this. First, the officer can simply turn the phone off or remove its battery. Or secondly, if they're concerned about encryption or other potential problems, they can leave the phone powered on and place it in an enclosure that isolates the phone from radio waves. Such devices are commonly known as Faraday bags. The court stated that if the police are truly confronted with a now or never situation, for example, circumstances suggesting a defendant's phone will be the target of an imminent remote wipe attempt, again, they may be able to rely on exigent circumstances to search the phone immediately. But as we are often reminded, it's going to turn on the totality of the circumstances and the ability of the officer to be able to articulate why that immediate action was necessary. The court also noted a couple of dramatic examples of exigent circumstances whereby a search of a cell phone incident to arrest could be made without the benefit of a warrant. There's no reason to believe that law enforcement officers will not be able to address some of the more extreme hypotheticals that have been suggested. A suspect texting an accomplice who it is feared is preparing to detonate a bomb, or a child abductor who may have information about the child's location on his cell phone. And the court noted, the critical point is that, unlike the search incident to arrest exception, the exigent circumstances exception requires a court to examine whether an emergency justified a warrantless search in each particular case. And there the court is going to look at the severity of the crime, the imminent threat of harm, and the time it would take to obtain a search warrant. In short, when you're dealing with the search of a cell phone, it's now going to take probable cause and a search warrant. It's the age that we live in.